Okay, that seems like quite a delicate balance. How is it done?
Well, that is indeed the art of regulating mediation. And one of the ways that it's done is by differentiating different regulatory forms on one hand, and also differentiating different aspects of mediation. So it's not as if you regulate everything about mediation in one particular way, right? You look at the different aspects of mediation that you might want to regulate, and you look at different regulatory forms that you can use to regulate those different aspects of mediation. So, for example, you can use private contract, your agreement to mediate, or a mediation clause, and two parties can write in whatever they like into a mediation clause to regulate a future mediation or the current mediation. So that's regulation by a private contract. You can have a written or an oral contract. Mm-hmm. Then there's also institutional or industry norms or rules. So, for example, the ICC mediation rules are a good example of that. Or in some industries, for example, the franchising industry in Australia has its own set of mediation rules for the franchising industry. Now, these aren't pieces of legislation. These are just sets of rules which have been written by this institution or this industry. They don't have the force of legislation or the force of case law or jurisprudence, but they have the de facto force of that industry or that institution. Courts also, particularly in common law countries, courts often write their own practice directions. So it's a way for a court to manage the way they deal with disputes. So a practice direction, for example, to go to mediation first, and different ways that mediation will be handled. They're all examples of, if you think, I guess, of the industry and institutional norms. Then there's jurisprudence, what courts say about mediation. Right, that helps us regulate mediation, right. How courts interpret these various rules. And then finally, the typical regulatory form that we think of, which is legislation.